Okay, so we've talked about the obligations of the parties to a contract. The seller must deliver conforming goods. The buyer must pay for those goods. If that performance doesn't occur, for whatever reason, then a breach has occurred. And we said the third thing that a contracting system does is to provide remedies for the breach of a contract. And so in this section, we're going to be looking at remedies. Now, remedies for the breach of a contract can depend on the type of breach. First of all, let's be aware that breach of a contract refers to a party's non-performance of a contractual obligation. A party has failed to perform, and therefore a breach has occurred. But there are actually two types of breaches. There are two different ways to breach a contract. The first is fundamental breach. And we have the same concept in the United States as well, except we tend to refer to it as material breach. We'll talk more about it in a second, but fundamental breach is essentially a failure, a complete failure of one of the parties to comply with their obligations. So obviously, in the case of a seller, it's failure to ship the goods. In the case of a buyer, it's failure to pay for the goods. That's a fundamental breach. There may be, however, a breach that's less than a fundamental breach, what we call in the United States a simple breach. And a simple breach, again, we'll talk a little bit more about it, but essentially a simple breach is something less than a fundamental breach. That's how it's defined, which means things like late payment or late shipment. Those things would be regarded as a simple breach. When we talk about material breach versus simple breach, what we really are looking at are the expectations of the parties. And in the case of a fundamental breach occurs when it results in such detriment to the other party as to deprive that party of what it's entitled to expect under the contract. So there must be a detriment to the other party, and that detriment must substantially deprive the party of what it expected under the contract, meaning the party's expectation was not met, usually at all. So if my expectation was never met, then that indicates a fundamental breach. So again, going back to the same thing, in the normal case of a buyer and a seller, if the buyer breaches and fails to pay, that's a fundamental breach. If the seller fails to ship the goods, that's a fundamental breach. Because in those cases, the buyer and the seller did not get the thing that they expected to get as a result of the contract. They didn't even get part of the thing. They were deprived of the entire thing. It would be as if we had a construction contract and you had hired me to build a new building, and I was a general contractor, and the building was a multi-million-dollar building, and there was a long list of specifications, and somewhere down the road I delivered to you a building that matched those specifications, except for 2 rooms were painted a different shade of cream. It's not fair to say that I breached the contract, although I did. I failed to do what I was obligated to do under the contract. But should I not be entitled to recover the purchase price of the building? No. Why? Because I mostly did what the contract called for. It doesn't mean that the buyer is going to not have options. They're going to be entitled to offset the amount that they pay me by whatever it costs to fix those 2 rooms. But nevertheless, it wasn't a fundamental material breach. A fundamental material breach would have been if I never started construction of the building, if I simply failed to start construction. Now again, the contract itself can always describe, identify what is a fundamental breach. Because this is sort of a gray area, what is it the party expected to receive and was it deprived substantially of that? Oftentimes, two parties entering into an international sales transaction would agree between themselves as to what a fundamental breach would be. And that way we don't need to worry, is a partial shipment a fundamental breach or a simple breach, if the parties have described in the contract what's necessary in order for those standards to be met. A simple breach, as I said, is a less than fundamental breach. So for your purposes and for the test purposes, understand that a simple breach would be anything less than a complete failure to comply with the terms of the deal. Either a failure to ship or a failure to pay. Any other type of breach, late payment, late shipment, things of that nature, those would be a simple breach. And the reason this is important is that the remedy can change depending on the nature of the breach. Was it a fundamental breach or was it a simple breach?